starting this course, let us praise and thanks to Allah Subhanahu wa Ta'ala, who has given help to us and the opportunity to attend this short course. And also let's give salawat and salam to Prophet Muhammad Sallallahu Alaihi Wasallam. Before we start this course, I would like to greet our speakers and participants today. Selamat sore, good afternoon from Indonesia time. Thank you very much for your enthusiasm in joining our course today. We are going to have such an up-to-date issue, a discussion entitled as Digital Technologies and Contract Law, Impact and Legal Challenges. As we know that technologies have had a significant impact, especially on contracts. It can transform the way contract created, executed, or managed as well. It also raises some concern about the validity, about the enforceability, authentication, jurisdictional issue, and so on and so forth. Now, regarding to that issue, sitting among us is our distinguished speaker, a scholar, Mr. Jeremy Kingsley from School of Law, Western Sydney University, Australia. Selamat malam, Pak Jeremy. Good night. Hello.
You want me to start now? Can you hear me?
Yeah, it's clear.
Okay. What I'm going to do is I'm going to share my screen. Is that okay?
I'm sorry?
I'm going to share my screen.
Oh, yeah, okay. I would like to introduce you to our participant. Prof. Jeremy Kingsley is scholars from School of Law, Western Sydney University, Australia. You may also find him in his writing. There are a lot of his writing regarding to Asian commercial law and transnational law. Mr. Jeremy Kingsley have written a writing entitled as Introduction, Reimagining Lex Mercatoria, published in Comparative Studies of South Asia, Africa, and Middle East in 2020. The Indonesia-Australia Comprehensive Economic Partnership Agreement, consequential legal document, published in Australian Journal of Asian Law, and the drafting inter-Asian legalities, Jakarta Transnational Corporate Lawyers, published in Adelaide Law Review in 2021. So before Mr. Jeremy deliver his presentation, I would like
I've lost you. Are you still there? Ibu Hanifah, are you still online? I've lost you. Is Ibu Hanifah there? Are you there? Can people hear me? Okay. So I think we've lost Ibu Hanifah. Should I start? How are we doing this? Sorry.
Sorry, I have an internet connection issue.
Okay.
And I think that I think you may start your presentation as now.
Okay, well, I'm gonna share my screen. Second. My apologies. Let me just. And it's not showing as a slideshow. Okay, I'm not going to worry about showing it as a slideshow because you can all, I presume, read the slide anyway. My presentation won't be, and thank you everyone for coming. I'm sorry, it's a little bit challenging because of the into the chat, and I will try to answer them as I can. Look, I'm a transnational corporate lawyer. I was, before being an academic, a lecturer, I was a corporate lawyer for one of the big global law firms. My specialization is Southeast Asia, primarily Indonesia. And what I am talking about today, not wanting to talk about, what I am talking about today is tech. Now, importantly, really what I'm going to be looking at is the way that technologies are transforming. You can't hear me. All right. Can you hear me? Can people hear me now? I'm unsure if you can hear me or not. Can people let me know? Because I've received a message saying you can't hear me.
I think that your voice is not really
I'm not
clear,
wanting
sir.
to proceed if it seems. Can people hear me? One second, I'll put my headphones in and see if that's any better.
Yes,
I think the
Professor.
connections felt a little unstable, but let's have a.
Yes.
Can people hear me better now?
It's better, sir.
Okay, let's start again. If you can't hear me, I'm not going to actually put my PowerPoints up because I think it may well be a little bit too much for the bandwidth that we've got. So let me start again by saying what we're looking at tonight is digital technologies and contract law. And in some ways, really what we're talking about. So people can't hear me still. Is it coming through or not?
In my device, it's clear, sir.
Okay, so I'm gonna, as long as you can hear me, I'm just gonna proceed, and hopefully other people will be able to hear. So third time lucky. Really, what we're engaging with when we're looking at digital technology and contract law is to think about, and from my orientation, is to think about how technologies are affecting both, I use the word human dimensions, which I'm really talking about lawyers. So how to affect the life of lawyers. And then I want to look at some digital dimensions, which is to look at key issues which will affect the way that we engage with concepts such as contract law. Initially, I was going to do human dimensions, then technological dimensions, but I'm going to inverse it because I think actually it's important to firstly discuss some of the technologies that we're confronting, and then look at the effect on the individuals, on the lawyers. One important caveat: this is primarily speaking to people who we would classify as transnational corporate lawyers, i.e., these are people who are operating in corporate law firms in Indonesia, almost exclusively in Jakarta, Assoc Hamza has an office in Surabaya, but that's just an exception. So, and well, similarly, these sorts of lawyers will be seen in limited firms in jurisdictions. These are the sorts of firms whose work relates to crossing borders, commercial law which crosses borders, and technology has made this more and more an issue. So really the issues that are affecting lawyers technologically, and I'm going to look at three key technologies. The first is machine decision making. And when we talk about that, we're talking primarily about AI, but it can be other forms of automated learning technologies. It's not just AI. Some of them are older style technologies which engage with almost like choose your own adventure books, in which, depending on an answer being yes or no, you move to the next section of the decision-making process. That's not technically AI. It's a lower, sort of more simplified form of automated decision-making, but you will often find that we'll cover a lot of things as being AI that aren't necessarily that sort of a technology. It is not an artificial form of intelligence. It's simply a decision-making process that's automated to receive yes or no answers. And depending on the yes or no answer, you'll move to the next stage or you'll move to a different sort of response. So that's the first sort of technology. You often see those sorts of technologies in relation to consumer products, in relation to, it's becoming more and more common in relation to adjudication of certain very minor matters in commercial realms. You also see the transformation in relation to digital technologies, in relation to precedent systems. Now, precedent systems are incredibly important because what they are is they are a series of base legal documents in which you are able to lawyers are able to modify those base documents. Now, the important part of this in relation to digital technologies is two things. Number one, these sort of precedent systems are becoming much more accessible. So in the past, only a very limited number of firms would have access to these sorts of very comprehensive repositories of contracts, which would which would cost a lot. And secondly, precedent systems are becoming more able to be and more user-friendly. Therefore, they are being engaged with significantly more. Now, that's a fairly unsexy sort of technology, but the sorts of databases that you need for those sorts of systems being housed on the cloud are really important for transactional lawyers, because they allow you to basically have documents to work from rather than sort of having very small in-house collections of documents. So that's the second thing. And the third area is automated contracting. Now, this is, you see actually usually on basic sorts of contracts, but more and more prevalent. And you see it all the time when you're doing online sales. So if you go to Amazon or you go to any of the, any sales point, you'll often sign contracts. You'll never read the contracts, but you'll sign these automated online contracts. And that's this sort of technology, which we're now taking as ubiquitous because of the way that we engage with sort of digital commerce, means that we're signing lots of contracts, we're engaging in lots of contracts in which we are almost unconsciously engaging with them. I.e., you want to buy a movie from Amazon or something, you want to get your access to Netflix or whatever it is, and you'll click onto a contract and you'll agree to it, but you'll have never even looked at a singular provision of that contract. So these sorts of automated contracts are affecting the way that we engage with this idea of contract law, because in those contracts, we don't. I mean, I could not tell you if the applicable law that I sign on to when I signed on for Netflix is Australian law, is it Singaporean law, is it United Kingdom law, is the contract to be understood in its applicable terms in English or in any other language? And these sorts of activities, these sorts of realities mean that, and these sorts of automation in contracts mean that our lives are often governed by contracts in which we don't have any conscious knowledge of, number one, what they mean, which is a bit of a problem or a very big problem. But secondly, it also means that you probably signing contracts in Indonesia or Bangladesh or Singapore or Australia in which the applicable law won't be the jurisdiction in which you're at. And you won't even recognize that. In Indonesia, for instance, you'll often sign contracts in which there is a dispute about this. Does a contract have to be in Indonesian for it to be applicable? Now, most contracts are bilingually agreed to, which means that in Indonesia you draft a contract in both Bahasa Indonesia and in English, right? Those two languages. But a lot of these digital forms of contracting, these automated forms of contracting, they don't do that. Are these contracts enforceable or not enforceable? So there's a whole lot of jurisdictional issues which are coming into play in relation to these sorts of automation of contracts, which are causing problems that have unexpected and unusual consequences to them. Now that is therefore, all these three changes to the technology, so there's sort of machine decision making, precedent systems, and also automated contracting, means that we're entering into a realm where our understanding of contract law as a discipline needs to factor in two things which we would not have had to feature into our analysis, say 20 years ago. And it doesn't matter, these two features does not matter if you are sitting in Australia applying common law notions of contract, or you're sitting in Indonesia applying civil notions of obligations, etc. In fact, these two things are becoming a bit of a universal problem. And the first is often any contractual arrangement, any commercial contractual arrangement we have is crossing borders in ways that mean sovereignty is challenged. It's the first thing, and like I said, that's a universal. And the second one is that these sorts of changes are happening at speed and often without us even knowing. So that leads me to the second part of the presentation, and this is an important, which is the human dimensions. And once I've gone through these, I really would like to open up the floor to discussion, because I think the experiences we're all having in this complex legal environment are really worth sort of nutting out and thinking through and talking about. So when we talk about this sort of human dimensions, the dimensions, and when I'm talking about human dimensions, in this regard, I want us to look at just one category of individual, these transnational corporate lawyers. So us, lawyers. And the first is that we need to factor into our understanding of the practice of being a commercial lawyer, speed of transactions. And speed of transactions can be the fact that they're automated, like I spoke to before, or that the negotiation and undertakings are happening at 2 to 3 times normal speed, if not faster. And what do I mean by that? Even on complex cross-border transactional negotiations, in the past, say I would draft a contract, I'd send or email or fax or it across. The other side would then mark in any changes and send or fax or email it to me. And so you go this process in which you sort of would stop and you'd start and you'd stop and you'd start. But now we're often able to work through cloud-based systems I mean, very simple sort of systems like Google Docs, but that's a very, very simple form of sort of these sort of systems, is that we can be negotiating and drafting the document simultaneously, i.e., I can be working on the document at the same time as Hanifah is sitting in Surakarta and drafting and amending the document. It happens simultaneously, which means the negotiation process is incredibly faster, because we can be talking, I can say, oh, like, I don't like the use of the word, you know, and, you know, here, and I would like it to be and or. And then the change happens like that immediately. So there's a speed imperative in our understanding of contract law. And the second part of connected to speed, and one of the challenges that this faces is, and the example I gave is, I am sitting I'm sitting in Sydney, and I'm drafting a contract with Hanifah sitting in Surakarta. Now, as we're drafting the contracts, in the past, when we looked at issues of jurisdiction, it was very straightforward and very simple. It would either take place in the past in Australia under the Commonwealth of Australia, or Indonesia under the Republic of Indonesia, and it would be that simple. I mean, it would never be that simple, but that's at least the way lawyers would like to think it was that simple. But the real problem that we have now is that often the only way that we know where the contract has landed in relation to substantive law, in relation to choice of language, in relation to any dispute resolution clauses that we have, is if we specifically draft them into the contract. Because the contract actually doesn't sit anywhere unless we say it sits somewhere, which means that you have this issue of jurisdiction becomes a lot more live. Now, let me give you an easy example of how this works in real life. Google, or ABC, I think it's called, it's corporate parents, is used incredibly widely in both Australia and Indonesia. Unfortunately, Australian and Indonesian tax authorities receive almost no tax revenue from Google. And the way they do that is but in the end, I'm looking at, I'm doing searches in Australia. You think that Google will get revenue from my searches, correct? It's a natural assumption. No, most of the revenue that will be generated by my interaction with this technology is actually picked up, is aggregated, and then picked up for tax authorities in Ireland. Why? Because Ireland has a very low taxation rate. Now, you'd say, but that's ridiculous. I'm undertaking all the searches, I'm doing all the purchasing, I'm doing everything off this platform in Sydney, i.e. the jurisdiction of New South Wales under the Commonwealth of Australia. But no, actually, we're existing in a digital world in which these sorts of situations become implicitly more complicated, and which goes to the idea of automated contract work. A lot of what we do is we'll sign off on all these arrangements, so we don't even know what's going on with them, and actually they'll move us technically from Australia to Ireland, as if we're magically in Ireland. And that, I mean, I'm not in Sydney, I'm in Dublin. These sorts of issues or challenges to jurisdiction are made even more complicated when you think about the sorts of contracts that we're involved with. Let me give you a very simple example. I go to Amazon and I want to buy a book. Now, Amazon runs as a marketplace, right? So it acts not just as a supplier of books, but as a sort of platform that brings together an array of vendors, array of people who sell books. I buy a book about Islam in Indonesia. I want to learn more about Islam in Indonesia, and I buy the book. The book is from a vendor based in Singapore. I'm living in Sydney. The vendor is in Singapore. And the book is in a warehouse in Solo. And the server farm that this transaction between me and the Singaporean vendor is actually in Thailand. So we've got 4 jurisdictions. My bank is not based in Sydney, it's based in Perth. And the vendor's bank is not based in Singapore, but Malaysia, i.e. we now have 6 jurisdictions at play. Where has the contract been made? Has it been made where I am? Where the money's taken out of my account? Actually, it's not in Sydney, it's in Perth, 2,000 k's away. Or is it made in Singapore where the money is received by the vendor? Or is it made in Indonesia where the product is held? Or is it made in Thailand where the server farm is, i.e. where the whole transaction has digitally occurred? Now, the way we resolve that is by drafting it into these contracts. So we choose amongst all of these players, all of these actors, where the transaction will actually take place. So that is a massive challenge to jurisdiction, because it then means that contracts can essentially not land in the jurisdiction that one would expect it to land. In fact, it may land in Malaysia because all of the way that the transaction is structured, it's the bank of the vendor in which the applicable law will be occurring in, i.e. Malaysia. Let's say it's Maybank. So what I'm saying is this second issue is this challenges to jurisdiction that we have to start taking to factor into account in very conscious ways. Connected to this challenge to jurisdiction is this notion of a privatization of law. It's sort of intricately connected. And what do I mean by privatization of law? That transaction that I just described to you was resolved not by the application of Indonesian or Australian law or Malaysian law or Singaporean law. It was resolved by what the contract, so the private document between the purchaser and the vendor. Okay, so it's a private arrangement. That is a privatization of the transaction. Often, these transactions also, depending upon the size, use private forms of resolution. You've seen now that in Dubai they've developed a arbitral forum for small claims, right? So sort of almost retail claims can be heard by arbitrators in Dubai for contracts signed between Australia and Indonesia. And also on a larger scale, what's happened is there's been international commercial arbitrations have gone from being a peripheral form of dispute resolution to being a major form of dispute resolution because of these contractual sorts of arrangements, these privatizations. And you can see that by the development of institutions such as SIAC in Singapore, the Hong Kong Arbitral Tribunals, Dubai International Financial Center, ICC in Paris, etc., 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 etc. And all of these arbitral forum, i.e. privatized forms of dispute resolution, mean that you can, remove domestic jurisdiction, i.e. they're privatizing our law, and it's occurring without us even recognizing it. And that's the challenge. So there's a challenge to jurisdiction, there's a challenge about the privatization. Now, I'm not making a statement of this being good or bad. That's a political, sort of an ideological assessment, but it is invariably meaning that the digital age is privatizing contract law. yes, obviously contract law has always been private law, but it has always been law applied in domestic jurisdictions primarily. And that is becoming more and more of a problem, or at least no longer the case. And the final thing I want to raise, and the final point I want us to talk about the challenge of the digital, is it's a semantic challenge. It's a bit more than semantics. It's a definitional conundrum, a definitional problem. Businesses in the digital age are transforming how they look and how they operate. Now, I'll use an Indonesian example because I think it's one of the easiest examples, but I could use it, could use it in any jurisdiction. Gojek or GoTo, right? Gojek can be defined as a transportation company because that's normally what it would be like. It's like Bluebird taxis in Jakarta that's a transportation company, right? They have, they run like a company. They offer taxi services like a company. They have different classes of taxis, and you sort of book on a system, or you hail them on the side of the road or outside a hotel. I.e., that's a transportation company. But Gojek doesn't define itself as a transportation company. The technology that it uses has meant that it argues that it is a platform in which drivers connect with consumers. So actually, they're not providing you with even though you have green jackets and they've got Gojek on the back and it looks like it's one company, actually what they say it is, correct or not correct, but this is the challenge of digital platforms, is that they say that they are a platform in which they link drivers to their potential passengers. Okay? i.e., the nature of the business is transformed by the technology. Therefore, when you're engaging as a lawyer, you need to realize that the sorts of contracts that you're going to make will be different because the requirements of businesses such as Bluebird, which is a traditional hard asset company, a taxi company, is different from Gojek, which is a digital platform providing transportation services, but not saying that it is the transportation services. See, this is sort of saying almost the same business, but not the same business. And that's a technological change. And so what I was wanting to sort of say in relation to contract law is that not only is it the technology which is changing, not only is it the challenges of the sort of jurisdiction privatization, but actually our clients are different. They have different problems. They face different ideas of liability. They face different issues of contract, or what they would prioritize when making or not making a contract. And so one of the things that we have to do when we're looking at this idea of digital technologies and contract law is to start to rethink the nature of the businesses who we are looking after and what they will need from our services, how they'll need our services. And for instance, it may be that Gojek is not so interested in the sorts of, payment systems for drivers. That may be, if you're looking at a traditional Bluebird model, they may have a very strong emphasis on the sorts of drivers they have, the sorts of contracts they have with their drivers, and the sorts of and billing regimes, ways of payment that they get, so when the driver receives money, the way the parent company gets that money back. But for Gojek, they probably don't care about that at all. The drivers aren't their employees. And they won't actually ever have any financial connection to the driver. All they'll do is every time a ride is is hailed, and I jump in on the back of a Gojek bike, what they'll do is they'll just take a small transaction fee off that connection. So it's a different relationship. They don't profit from the ride driver. They don't profit from the actual ride itself, me going from point A to point B. All they're going to care about is that I jumped onto the back of a driver using their platform. And so therefore it may be not about how much they get for that ride, but just having lots and lots and lots of rides. Do you understand? So that each time the driver uses the app, they'll get 2,000 rupiah or whatever it is. But if you have 10 rides in a day, that's 20,000 rupiah by the end of the day. But that's a different contractual sort of relationship. It's not with the driver, it just takes off the top of the transaction. So what I'm trying to say is that when we're looking through and we're engaging with these new technologies, we're engaging with the way these new technologies are working, we need to remember that our clients are different. And they will want to contract differently. And that's the real challenge for lawyers in today's world, is to trace the sort of shifting sands. The shifting sands of the technologies that are being used, the shifting sands of the sorts of effect on legal systems that is occurring by those technologies, and finally, the difference that it's making to the business culture in which we're working in, right? And those three key factors, two of which are sort of human dimensions, and the one which is technological dimension, really is radically altering what contract law is in a substantive sense and in a practical sense. And on that note, I'm happy to take any questions or discussion or that anyone would like to have.
Yeah, thank you very much, Mr. Jeremy, for the insightful presentation. I myself very happy to hear your presentation. It's some part of this are kind of new for me personally, and I like to hear how you relate the material with our context in Indonesia, especially. So, dear participant, it is the time for question and answer and discussion as well. If you have any question, please, you can directly ask to Mr. Jeremy, or you can use raise hand feature or drop your question in a comment section as well. Maybe Miss or Mr. Ponpiron, would you like to ask directly to Mr. Jeremy? Hello.
I can see the question.
Yeah. Okay.
And I'll try and answer it, and you can so you can't avoid technology. I mean, it's not about whether you want to be involved in the digital world or don't want to be involved in the digital world. We are involved in the digital world. That's the reality. I mean, the reality is that I have sitting here my smartphone. I'm sure everyone has sitting in front of them their smartphone. Everyone would be using services from Gojek to Amazon to Netflix to, a million and one, all of our banking. I mean, if you go to Bank Mandiri now, I don't think in Indonesia, I doubt you'd ever go to a branch. Maybe you would, very rarely. And it would be to set something up or to show some form of identification. So my thing to you is that that's just unavoidable. How should blockchain, big data, and analytics? Okay. Okay. Well, blockchain is just a technology in which you have linked databases, usually which are encrypted, and you need a key. Either they're open access, i.e., people can they're open, or they're encrypted, in which you need a key in which to get to the next stage of the data. I mean, of the sort of ledger. Blockchain is a perfect example of where governments are struggling. So I know that OJK, the sort of monetary authority in Indonesia, regulator, is struggling with this idea of how to regulate blockchain. One of the challenges is if it's encrypted and the national regulators, whether it be ASIC in Australia, OJK in Indonesia, or the Financial Authority in Singapore, the big problem they have with blockchain is if it's encrypted, they can't peer into the contract, into the ledger, i.e., they can't see what's going on. And that's, from a regulatory perspective, very daunting. So a lot of the blockchain is, the questions about blockchain are related to whether or not you allow for the encryption to occur and how that occurs. Big data analytics, big data analytics is just lots of numbers in these very complex quantified through very supercomputers. Now, they are important in relation to aggregation of things, like the example I gave with Google moving my tax obligations to from Australia to Ireland. Part of how they do that is by the aggregation of data, which requires big data analytics. And artificial intelligence, well, it's going to be used in an array of different ways, from the ChatGPT sort of stuff where someone will type in, I want a contract on thing, and someone will, ChatGPT will draft it for you. But although those are problematic for lots of reasons, but really artificial intelligence will be used. It will be used as a way that we will, in some ways, like precedent systems, in which we'll use them alongside the nuance of organizing contractual arrangements. But on day-to-day, small-scale retail contracting, artificial intelligence may well soon be the way it all works. That's the challenge. How much human intervention do you have in the technology? What kind of legal problems can be caused by smart contracts? Where do you want to start? The challenge of technology, and this is a general challenge, is that the technology offers the opportunity to do things with a lot quicker, with a lot less human input, right? So that's the benefit of these sorts of systems. But the problem with these sorts of systems is that often when you include the best example of that is that, I don't know if you heard about it, but over the weekend, the US government was simulating drone technology which used AI to so instead of having someone sit and move a drone and then drop the bombs on target, what happened was that they used AI to drive the plane, and then simulate driving a drone, and then firing the drone. Right? The problem was that once the operators realized what the drone was doing, and the drone was going to complete the mission, the drone was going to kill, hypothetically, kill hundreds of civilians. So because it was focused on the mission, and the mission was to get rid of this military site. So a drone, so the human influencer in this technology tried to stop the artificial intelligence from completing the mission because of the costs of completing the mission, the civilian costs. and the AI turned on the human operators of the system, i.e., it reversed the target and started to target the actual pilots. So what I'm trying to say is that all of these things, smart contracts, things like that are great in theory. The problem is if you let them go without thought, what happens is often incredibly unintended. The consequences we don't know. So my thing is not about whether smart contracts are good or bad or what sort of problems they create. Often the problems that they create are if we don't have human intervention in them, and we think that will be okay, right? And if you've been in Australia, you'll know that we had a government system that dispatched for welfare payments and attract people who they thought were abusing welfare payments. The problem was that the algorithm that they used was getting it wrong, very wrong. So this idea, what I'm trying to say is it's a cautionary tale. Things like smart contracts, things like AI can be really, really productive. The question is if we cede control or become lazy about the application of these technologies, then you can have really sharp and often totally unintended consequences. So, things that you don't think can happen will happen because, you have started a process moving, but not monitored that process, that technological process.
Okay, thank you. Others, do you have any questions from Bangladesh, maybe? Do you have any question, or you may give context from your country as well? Or others from Vietnam, or student from Universitas Muhammadiyah Surakarta? Okay. Hello.
Ya Allah, terserah teman-teman.
Belum, Bu. Okay. Students and participants, do you have any further questions? Well, I have questions, Mr. from myself. Talking about the issue of Google, you have mentioned earlier that I think how do the government should do? How do they put their position? For example, like if we do not regulate them, we may do not get the revenue as well. But if we regulate them, I think it also decrease the ease of doing business in Indonesia as well. They may go to other countries as well. That's the question for me.
Yeah. I mean, that's a very tricky question, because Indonesia, like this goes for all countries. We all want to attract business. We all want to attract, commerce. And therefore you don't want to put roadblocks in the way of these sort of businesses. The problem with that is, though, that it's in some ways like saying they're stealing tax from you, from us, from everywhere. And it's in some ways, I think, a little bit about this question of where do we want law to be? Do we want law to be enforcing national imperatives, and therefore tax is important? Or do we say, look, it's much more important that they just do business in Indonesia, and that's the only priority that there is? I tend to think that it's very cheeky from Google to simply strip tax revenue from countries. Primarily because the data is quite incontrovertible that tax is the best form of social support. Zakat, charities are good, but they never a replacement for tax. And so if you're gutting a tax, if technology guts a tax system, then there's a problem. That's just my perspective. I know there's a balance, and people may have different perceptions of how you deal with that balance, but in the end, and I think it's very important for, my perspective, it's very important for Indonesia, very important for Australia to have a tax base which can do things like education, can do things like a health system. Otherwise, how does it happen? And technology companies can very easily avoid these sorts of regulatory constraints. And I think we've got to be very cautious of how much they avoid. That's my answer.
Okay, thank you very much. It's still like a warm discussion regarding to this issue as well, yeah.
Yeah, and it's about that discussion is really about how we perceive the role of commerce in generating social underpinnings. So, like, how much should a business contribute to the social welfare of society in general? Maybe I'm more. I believe it's really important that we don't forget those sorts. We don't forget. You can't have Pancasila and look after Bangsa and then have no money for that. It does take money. Sorry, it's true. You can't buy rice without money. And I don't say that. I really don't say that in a greedy way. I say that in the way of saying, when we're talking about challenges to sovereignty, this is where contract law is really challenging sovereignty at the moment.
Okay, thank you very much.
And so I've got a question about what sort of safeguards can be implemented when using online platforms. Okay. So it depends what we're talking about safeguards. There are one of the things that I think is really important in relation to, one of the things that I think is really important in relation to safeguards, and I'll take this question from two different ways. The first way is in relation to consumer protections. And that's that sort of idea of the sort of automated contract law sort of stuff. Now that, the amount of online consumer contracts that happen just every day for, across Indonesia, across Australia, across Asia, everywhere, it really means that we need to think, what sort of protections for consumer rights do we want to have in those sorts of contracts? And the sort of things we should do is, I think you really need to have some basic rights. We need to make sure that basic consumer rights that exist at the moment aren't diluted by these sorts of contracts. So my belief is that if a product is being sold into a jurisdiction and they are consumer products, that the products should have, the contracts should have, as a means of, as a basic bottom line safeguard, have provisions from Indonesian or Australian consumer protection laws embedded into those contracts. That would be the first safeguard, because like I sort of said, one of the real victims with online platforms is us. Just, so we sign on to all these contracts like that all the time, and we don't ever think about it. I jump on the back of a Gojek bike and I sign a contract. I don't think, what does that contract involve? So like I said, the first thing is those consumer protections, i.e. the protection of, which can go to things like our data. The Indonesia has certain provisions about privacy of data, and those consumer protections should be embedded into these, sort of automated contracts. That's the first form of digital protection, for consumers. But then it's very different if we're talking about safeguards for larger marketplaces. And in this way, I'd look at two sorts of contract. The first sort of contract is those that relate to, a lot of times those contracts are online and digital. So if you go buy and sell, trade in securities, that happens like that at very quick pace. And in fact, often what happens is that those contracts that we sign onto for sale of securities has sort of indicators. We'll purchase at this price, we'll sell at this price, and we'll hold if it's in between these ranges. One of the things that I'll talk about in relation to those protection of those sorts of marketplaces is related to market volatility, right? If you, in 1997, when Indonesia hit a financial crisis, what happened was that there was a call on short-term money market proportion of short-term loans, right? They were traded through the market and they all got called in within a 3-month period. And each time you call in one of these contracts, it causes more and more chaos. So my thing would be, if you're going to make these sort of processes automated, there needs to be safeguards to avoid an economic meltdown, like happened in 1997 in Indonesia. That wasn't an that was a very early form of automated arrangement, but it shows you how quickly it can crash an economy. It happened in Thailand too, it happened in Malaysia too, and it affects economic crisis markets. They were online, but they were sort of beta models. And what I would say is that if you're going to be looking at these sort of bigger markets, that you have to have safeguards to avoid economic inferno. I mean, that's really what, because if you can trade millions and millions of these sort of debts very, very quickly, like in space of hours, you could theoretically crash an economy at lightning speed. And you see that in relation to some of the runs on the banks in America in recent months, in which the only way of stopping the run on the bank was to suspend the electronic trade of those banks. So they had to have a circuit breaker to stop the crisis. So that's sort of a bigger marketplace crisis. So those are the sorts of, once again, it comes back to what I was speaking in relation to one of Hanifah's earlier questions, which is that there needs to be points in which human interaction interfaces with technology, especially at crisis moments, so that certain things can't just automatically happen. Because if they do, then you can have crises that arise very quickly, are all based on contracts, are all valid, right? But it becomes like a fire you can't control.
Okay, thank you, Mr. Jeremy. Is there any else to be discussed from participants? Or from students? Or maybe I would like to hear if participants from abroad, like Vietnam or Bangladesh, would like to give some context in their country. Hello. Do you have any question or statement, maybe? Students, do you have further questions? One last question from me, Mr. Regarding to predatory prices. Maybe you I think the predatory prices from big companies, like they sell some stuff in a very cheap price in order to promote their platform. However, in other side, it also kills our small enterprise. What is your opinion regarding to this, and how to regulate this as well? Or maybe you have any best practice?
That's a very tough. Predatory pricing is very tough, and the role of digital platforms is very complex. So let me give you an example. It was called the negative investment list. Now it's called the positive investment list. But into Indonesia, if a foreign business wanted to invest, you had to check what industry you were in, and you went from a sliding scale of 100% possible ownership, foreign ownership, but most actually didn't start until about maximum of about 60% foreign ownership. The one exception to that in Indonesia, a very clear exception to that, is digital platforms. Okay, so I can own, let's say I'm Jeff Bezos, and I own Amazon. I can buy out Tokopedia and absolutely dump products into Indonesia. I mean, I can halve I can quarter the prices, like it, because I have enough buffer, I have enough fat on my balance sheets that if I want to, I can spend. And you're right, I can destroy either local digital platforms, but really where the destruction occurs is retail outlets. And you'd find, but I believe, to be very frank with you, you spoke to any major retail business globally, and they'll all say the market is significantly tougher because of digital platforms, right? I mean, so the first problem you have is a digital platform doesn't have the cost of a building, doesn't have the cost of staff just walking around the front. I mean, they have staff, but they're only responding to, if you buy something, I'll go to the back and bring it up and I'll pack it and I'll send, trade it off. That's all they need. They don't need salespeople. They don't need, advertising. They don't need to make the space. I guess they make the website look good and stuff like that. But actually, the costs are very much lower straight away. And so I would split this problem into two separate problems. The first is this issue of how do you protect this retail outlets generally, because there is a benefit to having a store. There is a benefit to having a branch, and so these retail outlets, the question is, how do you, irrespective of the technology, how do we save them? Because I mean, even if you think about it, what's one of the most important ways of socializing across Asia, across the globe? Going to malls. What do malls need? They need shops. Right, so that's the first, and this is a direct challenge to that whole business model. It's an absolute direct challenge to that. That's not pricing. That's just pricing. But you're right. How do you deal with these issues of sort of dumping, predatory pricing, dumping of goods, etc., etc.? And I would say the only real tools that we have available to us within our legal systems relate to competition law, i.e., that you target these sorts of businesses for anti-competitive practices. That's the way that's the way I would attack it. You sort of say, look, these businesses are being anti-competitive, and therefore we would bring into effect the Indonesian, Australian competition law authorities in order to seek to moderate that sort of behavior. That would be the way that I'd answer it. Someone asks about cryptocurrencies and disputes about cryptocurrencies. Well, cryptocurrencies are everything and nothing. I mean, who knows what's going to happen with cryptocurrencies? There's a real problem with cryptocurrency, and this is the first real problem. What's the backing for it? The reason that I use Australian dollars, the reason you use Indonesian rupiah is becomes sort of backing to value. There's a value to it. And that value doesn't disappear. It's the means of making a transaction. Crypto, and it's the trouble with crypto, is not, number one, it's fluctuating wildly from being, you know, one crypto coin being worth 42,000 Australian dollars to one crypto coin being worth $2. I mean, and this could be 2 days apart. That's that part of the problem with crypto, that it still hasn't yet found a means of replacing sovereign currencies. Now, I just came back at the end of last week from Beirut, and in Beirut, they know the lira is which is the Lebanese national currency, is so devalued that they've replaced it not with cryptocurrencies, but with the US dollar. So what I'm saying is that cryptos have been much hyped. They're also really hard to know what their future will be. And I'm not saying it's not valuable. I'm just saying it's a wide array of things. And someone says, someone asks, how will you be protected? Cryptocurrencies be protected? Well, cryptocurrencies per se won't be protected unless they're protected by and or issued by sovereign funds, i.e., that the Indonesian, Bank Indonesia, and Bank Indonesia does, I believe, have a cryptocurrency, same as as there are cryptocurrencies in the Australia that are backed by the Reserve Bank in Australia, but they aren't the cryptocurrencies we're really talking about. So those are basically Indonesian rupiah or Australian dollars, but just in a form of an electronic forms of those things. But cryptocurrencies which are private, exchange on the market, as we've seen by the massive collapses which have occurred in America, and the massive plunges and aren't necessarily protected under law in any jurisdiction, and it would be one of the hard things. This goes to blockchain, is that these cryptocurrencies are being used in blockchains that are encrypted and that we don't know how they're being used, right? So once again, that can't be at all protected by the state. So part of this discussion of crypto is this idea of where does it get its innate value from, which is what I was just talking about. And part of it comes from this idea of what technologies are cryptos using in order, and who is using them and for what purpose. So if it's an unlawful purpose, then it's great. The Indonesian regulator can't check it. Great if you don't want Paul Reed to know what you're doing with your money. Great if you don't want the Australian Federal Police to know what you're doing with your money, but then the protections will be significantly less. You sort of see what I'm saying? These are all, so that you're dealing with both this idea of value, sovereign value, i.e. what the value are for these currencies, and also this idea of how cryptos are being changed by technologies and what technologies are available to us.
Okay, thank you so much, sir. One last call, maybe there is further questions or comments from participants. No? Okay. Dear participant, you can fill the attendance list in the section, in the comment section. Okay.
Wonderful.
It's very insightful discussion, sir. Thank you very much. I learned a lot of things in this opportunity as well. We have discussed a lot of things, starting from automatic contracting. We are talking about how this automatic contracting affect our daily basis. For example, even we just click on Netflix or Google or something like that, somehow we are not aware at all that we actually just signed a contract. Thank you very much for the reminder.
Often for lots of money.
Thank you very much for the reminder, sir. And also we're talking about a very insightful discussion regarding about sovereignty and jurisdiction. Mr. Jeremy Kingsley have delivered even just a simple example like buying a book, yes, sir, yeah. But buying a book could involve like 6 jurisdictions related to just buying a book. Thank you very much for the insight as well. And Mr. Jeremy also delivered about the privatization issue and also the issue about cryptocurrency as well. Thank you very much. We are very happy to have you in this opportunity, very insightful. I think we are on the end of our discussion. On behalf of the committee, we also send our thank you for the speaker, especially Mr. Jeremy, and for all the participants. Thank you very much for joining in our course today. Last but not least, we still have another session for tomorrow, another insightful discussion again. Please stay tuned on the WhatsApp group for more updates. Tomorrow will begin at 9 with other presenter as well. I think that is all for. Okay. Thank you very much. Terima kasih, Pak Jeremy. I think that is all for me. Thank you.
Thank you.
Thank you. I would like to apologize as well if there is a mistake during the discussion. See you on the next event. Wassalamualaikum warahmatullahi wabarakatuh. Thank you, Prof. Jeremy.